Hello, I'm Kate Feeks. Welcome to this edition of Medina County Court News. On Thursday, February 16, 2012, Mr. Tanner B. Smith of North Ridgeville, Ohio, appeared in court with his attorney Michael Ash to enter a change of plea to two charges. One charge was theft in excess of $7,500, but less than $150,000, a fourth-degree felony. The other charge was safecracking, also a fourth-degree felony. Here is Judge Kimbler taking Mr. Smith's change of plea.
We're calling case number 11CR0624, State of Ohio versus Tanner Smith. Let the record reflect that Mr. Smith's in court with attorney Michael Ash. State of Ohio's in court with attorney Matthew Rizzavi. Attorney Rizzavi, what's the understanding of the State of Ohio?
Your Honor, we're expecting a no contest plea. Charge of the indictment. It's two counts. First count is theft. Second count is safecracking. They're both felonies of the fourth degree. They carry with them a possible prison sentence of between 6 to 18 months, monthly increments, and a fine not to exceed $5,000.
Okay. Is that your understanding, Mr. Ash?
It is, Your Honor.
You are Tanner B. Smith?
Yes, I am.
You are an American citizen?
Yes.
Do you read, write, speak the English language?
Yes, I do.
Are you now under the influence of alcohol or drugs of abuse?
No, sir.
At the time of this offense, were you 18 years of age or older?
Yes.
Since you turned 18, has a probate court ever appointed a guardian to handle your money?
No.
You are here today in a criminal case. In the criminal case, there are 4 pleas that you may enter. They are a plea of not guilty that you previously entered that denies each and every element of the crime, a plea of not guilty by reason of insanity, which says you did the act but you're legally insane, a plea of guilty, which is a total admission of your guilt, and a plea of no contest. A plea of no contest is not an admission of your guilt, but it is an admission of the truth of the facts set forth in the charging document. If the facts set forth in the charging document constitute a criminal offense, you can and will be found guilty on a plea of no contest and treated as if you pled guilty, but the fact you've entered that plea cannot be used against you in a subsequent civil or criminal lawsuit. Do you understand those pleas? If you enter a plea of guilty or a plea of no contest, you are giving up or waiving certain valuable and important constitutional rights, and these rights are as follows: the right to a trial by jury, to have your guilt proven by proof beyond a reasonable doubt, to subpoena witnesses on your own behalf, to cross-examine those witnesses called as suit against you, to have the services of your attorney at trial. You're giving up your right not to incriminate yourself, and you're giving up your right to a speedy trial. You understand you're giving up those rights?
Yes, I do.
You understand if you went to trial, you would not have to testify, and the fact you did not testify cannot be used against you.
Yes.
You are here today on 2 felonies of the 4th degree. One is theft, and the other is safecracking. Both of these took place on the 27th day of October, 2011. Right, 2011. Right. Okay. And so both would carry the same possible prison sentence, which would be 6 months to 18 months, and 1 month increments, and a fine up to and not exceeding $5,000. Do you understand all that?
Yes.
Okay. If you went to prison for either one or both of these offenses, and only if you went to prison, when you were released from prison, the State of Ohio could but not have to put you under what's called post-release control for a period not greater than 3 years. During that time, if you committed another offense or violated certain rules and regulations of the Adult Parole Authority, they could put you back in prison for up to 1/2 the time I gave you, independent of, in addition to any other penalties. You understand all that?
Yes.
Anybody make any threats and promises to get you to change your plea?
No, sir.
Did you tell Mr. Ash everything there is to know about the case?
Yes.
Are you satisfied with your services?
Yes.
Do you have any questions for myself?
No, sir.
If you need to talk to Mr. Ash outside my presence.
No, sir.
The theft charge reads as follows: on the 27th day of October 2011, you did knowingly in the County of Medina, State of Ohio. You did with purpose to deprive BL, the owner of property or services, to a U.S. currency, knowingly obtained and exerted control over said property or services, that being the currency, without the consent of BL, the owner or person authorized to give consent, the value of the property being $7,500 or more, but less than $150,000. This is theft, felony of the 4th degree, in violation of 291302A1. Do you understand the nature of the charge?
Yes.
Do you understand the nature of the penalty?
Yes.
How do you plead today?
No contest.
Waive presentation?
Yes, sir. We
And do you now withdraw your not guilty plea?
Yes.
Count 2 is on the 27th day of October 2011 in the County of Medina, State of Ohio. You did with purpose to commit an offense, knowingly enter, force an entrance into, or tamper with a vault, safe, or strong box in violation of section 2911.31A of the revised code called safecracking, a felony in the 4th degree. Do you understand the nature of the charge?
Yes.
Do you understand the nature of potential penalty?
Yes.
How do you plead?
No contest.
Waive presentation?
Yes.
And do you now withdraw your plea of not guilty?
Yes.
Anything further from the change of plea in the state of Ohio?
No, Your Honor.
Anything further from the defense counsel on the change of plea?
No, Your Honor.
The court finds for the record that Mr. Smith made a knowing, voluntary, and intelligent change of plea. The court took the change of plea after it was satisfied by inquiry that he did understand his criminal role and the constitutional rights. He did make the plea in open court and upon the record. Therefore, in count 1, it finds him guilty of theft in violation of RC 291302A1, felony in the 5th degree. I'm sorry, 4th degree. Count 2 finds him guilty of safecracking in violation of RC 291131A, felony in the 4th degree. Orders of PSI will impose sentence on the 22nd of March 2012 at 8:30 a.m. You're not seeking revocation of bond, are you? Bond is continued. Okay, that's it. Can I see counsel and probation sidebar? Actually, this is defense counsel.